saying that it's a pre-cognizance stage, that means that post-cognizance, such direction to investigate should not be given. Section 157 now comes and says that the procedure for investigation. So investigation begins, we all know that it begins with FIR or any other information about cognizable offense. If there is an information that a cognizable offense has been committed or an FIR is lodged, in such case, the uh, procedure for investigation would begin. Prompt information about FIR to the magistrate, that is one important provision given, that once FIR is lodged, it shall be made over to the magistrate. The reason being, as I already told you, that the purpose behind it is that magistrate is nothing but the head of that justice enforcement mechanism, and police is acting on behalf of it. So whatever is done, whatever steps are being taken by the police, it has to be informed to the magistrate what once. And this section also says that if no investigation is made, then a report to that effect shall be made and it will be sent to the magistrate. Another important power under investigation is to arrest. Without that, the investigation can never be completely fruitful. So chapter 5 deals with arrest. We'll not discuss it at length. We'll just discuss some of the important provisions. That is, section 41 says about the power to arrest without warrant. In Siddharam versus State of Maharashtra 2011 case, it was held that power to arrest is not arbitrary, and only when the accused does not cooperate, this power should be exercised. That means this power should be exercised very sparingly, though our system acts otherwise and the power of arrest is arbitrarily used by the police and sometimes also misused. But then Siddharam versus State of Maharashtra, this was laid down that only when the accused is not cooperating, then only the power of arrest should be exercised. Section 41A, this is another important power which has been vested with the police officer, that notice of appearance before a police officer. So where arrest is not required, if the police officer is of the view, so it's a discretion that the arrest is not required, then the police officer can issue a notice with a direction that he will appear before the magistrate when it is required. Section 41B says the procedure of arrest, and DK Basu versus State of West Bengal 1997 and Joginder Kumar versus State lays down various guidelines while arrest is effected. Agnes Kumar versus State of Bihar is another landmark decision in this aspect, and power to arrest must be on reasons and not arbitrary. And entire jurisprudence of arrest has been narrated in this case very beautifully. Please go through this Agnes Kumar judgment. On the basis of that, 41A notice actually works in our justice system. So please go through that. Section 50 says that right to know the grounds of, these are the rights of the arrestee, that is right to know the grounds of arrest, right to know about the bail available in a bailable offense. Section 54 says right of medical examination. Section 57 says about right to be produced within 24 hours of arrest. Section 303 about right to have a legal counsel. Section 47 that when a woman is arrested, then other than a woman officer, no one can touch the person of the woman, and the woman has to be arrested after sunrise and before sunset. So after sunset and before sunrise, she cannot be arrested except for special reasons recorded. Now coming to section 158, it says that report how submitted. So it basically is not an important provision. It says that if there is a superior officer appointed by a state government, then such report has to be submitted through that superior officer, and he may give instructions thereon and then send it to the magistrate. Section 159 says that power to hold investigation or preliminary inquiry, which means that if the magistrate gets a report from the police, the preliminary report and the FIR, where the police says that he does not want to proceed with the investigation, then the magistrate can do one of the following things. The magistrate can either proceed with the case, or he can order that if order that an investigation to be done where police has decided not to investigate, or he can also depute a subordinate magistrate to hold a preliminary inquiry that whether investigation is actually required or not. Section 160, it says that basically the police can require any person acquainted with the facts and circumstances of the case to appear before him and uh, cooperate him in procuring the truth. But the woman witness or persons below the age of 15 years shall be examined at their place of residence. That is an embargo given in section 160. Now comes the very all important provision, section 161 and 162. This is very important. Please be careful. Examination of witness by police. Basically, it is nothing but a statement made uh, before a police during the investigation. So it says that the police can examine any person orally, including the accused. If that person or the accused, obviously accused is acquainted with the facts, but any person, if they are acquainted with the facts, then the police can examine them orally, and such person or the accused are bound to answer them truly. They have to answer it truly, except where such answers can expose him or them to any criminal charge, offense, penalty, or forfeiture, as the case may be. In such case, uh, uh, such answers are not to be given. It is basically based on the constitutional mandate fixed, which says that no man is to be compelled to be a witness against himself. So, in such case, if only if he is acquainted, he has to depose it truly. But then, if it is exposing him to a criminal charge or offense or penalty, then he must not be required to say it. So, police may reduce it in writing, but the signature of the such person are not to be taken. That is mentioned in section 162. We'll come to that. Section 162 says that any statement which was recorded by the police while the investigation is going on, uh, those are to be reduced in writing, but they are not to be signed. The purpose is very clear because law enforcement mechanism or the legislature does not trust the police a bit. They think that they are overzealous. They tend to become uh, prejudicial against the accused, and they'll be uh, trying to make sure that a conviction is made. So that's the reason. If a statement is reduced in writing, it is not to be signed and not to be used against the accused. These are the embargo given by 162, that it is not to be signed and it cannot be used against the accused as well. But if it is in the favor of the accused, then it can be used. 162 says that it has to be, it cannot be reduced in writing. It is not to be signed. It can be reduced in writing, not to be signed and not to be used against the accused, but can be used in favor of the accused. We also have to remember that it can also be used for contradiction under section 145. That is, if a witness has been declared hostile, then in such case also the previous 161 statement that he made before the police, that can be used, and he can be asked that on such and such date you had made this statement before the police that while you were present, the police seized 700 liters of mahua liquor from the possession of the accused. But now you are changing your statement. What do you say? Then he'll say that no, I did not make such statement, or whatever it is. But then it can be used for contradiction. But we also have to know that it cannot be used for a contradiction of a defense witness or a court witness. So basically, you please see that you see this. All the provisions are made to make sure that the accused is benefited. Arrestee, accused, because the principle is what? Principle is that he is to be presumed innocent until proven guilty. So all these laws are accused centric. All these penal statutes will be given a beneficial interpretation. There was one question that uh, probably I was discussing with some of my friends that uh, it is not related, but then I'll just give an example that uh, under in IPC it has been given that Dolly in capax principle is there in IPC, Dolly in capax principle, that below 7 years of age, uh, persons below 7 years of age, they will not be attributed any criminal liability. But if they are between 7 to 12, more than 7 and less than 12, then they're whether they understand the nature of the act, that has to be looked into. But there is no provision. If you go through those two sections, please let me know once you go through them. There is no provision specifically mentioned for a person who has just attained the age of 7 today and has committed the offense. So what about that person? Please, if anyone knows, please tell me what about the position of a person, I mean a child who is just 7 years of age, because that is not clear in law. So in what case, in that case, what will be the position? Whether he'll be treated as Dolly in capax, that is below 7, and he'll not be attributed criminal liability, or whether he shall be taken into the category of 7 to 12, and he shall be attributed to this provision that whether he understands the nature of the act. Okay, that is, let's not divert from the topic. We have a lot to cover. So my point is that these are accused centric laws. So also, it cannot be used for corroboration. Rameswar Singh versus State of Jammu and Kashmir, it made it clear that such statements made before the police during investigation, they cannot be used for corroboration. And also, you have to note that prosecution can obviously contradict under Section 145 Indian Evidence Act, but it has to seek permission before the from the court. Of course, before declaring hostile, they cannot be asked such contradictory statements. So permission of the court is a must. So now, if omission to state a fact or circumstance can be a contradiction if relevant or significant. So it is saying that this is probably a concept that I picked up somewhere, which says that uh, omission to state a fact or circumstance while deposing, and before 161 you had actually made that statement, that can be also relevant. So basically it's a way to prove the contradiction. Nevertheless, it's not required. I just said it like that. Also, we have to know that identification of property before police is hit by 162, and hence they cannot also be they can also not be uh, uh, used for corroboration or contradiction if it is a defense or court witness. Now, there are two questions which you obviously will answer me at the end of the session. That will this statement still be hit? Will this statement still be hit if made before police during any time other than investigation? I hope everyone notes them down. Don't please tell me that we did not note it down or we forgot the question. I'll have to come back again here. So please note it down. Will the statement still be hit if it is made before the police during any time other than the investigation? And second question is, what about statements made by the accused before some other persons but recorded by the police through voice recorder? That means that if a person is not made before the police, but that is recorded by the police through voice recorder, in what will be the scenario in such case? Please answer me at the end of the lecture. Now I'll tell you what are the deciding factors while making sure that whether it is hit by 162 or not. First deciding factor is whether the statement was made before the police or made before anyone else. Second deciding factor is such statement was made during the investigation or at any other time. Third deciding factor is whether it is to be used in criminal inquiry or trial, or it is to be used elsewhere. That is, if it is to be used in civil proceeding, then it will not be hit by 162, and so it can be used against the accused in respect of the offense. Fourth is in respect of the offense which is being investigated currently or not. So that means if it is in respect of an offense which is not being investigated currently, that means the accused now says that say while actually investigating into a theft, the accused came and said this statement before the police. And quoting it, the accused stated that I am confessing that I have stolen this particular motorcycle that is being alleged here. So this part of statement, because it reveals to the offense which is being investigated currently, that will not be used against the accused. But if he says subsequently that yes, I had done this theft, true, but also on 17th November 2020, the 17th November 2020, the robbery that occurred in CDA, I was also a part of that. If he says this, that can be used because this is not the offense that is being investigated currently. So in such case also, it will not be hit by 162. So these are the deciding factors. The exception to this rule is that statement leading to discovery. We all know statement leading to discovery of a fact made before the police. If it is admissible under Section 27 Indian Evidence Act, then it will not be hit. That means if an accused says that I have hidden the weapon by which I killed the person, killed Ram uh, near the pond in a bush, and that, and he actually takes the police to that place, and from his statement that uh, weapon of offense was recovered from that place of uh, where the accused actually showed it to the police, then such discovery, that discovery will not be hit. Such not just statement, that discovery of a fact, that fact of discovery will not be hit by 160. So 163. Now we have discussed 162 nicely. Now we'll go to 163. That is, police or investigating authorities are prohibited from making, offering any promise. So basically, it is to make sure that the accused is not making any revelation because the police actually pressurized him, or they promised him something. So you must have seen in movies, they say that you सीधे सीधे cooperate कर दो, and क्या पता मैं तुम्हारा सजा कम कर दूं. So if he makes such of promise, or he says that you either you please, either you not please, either you reveal the entirety of the truth, or I'll make sure your family suffers the loss. If police makes any such promise or inducement, then to extract information, if such inducement or threat or promise is given, then those are not not to be done, and Section 163 prohibits. And also false facts like generally it is also used by the police, saying that the other accused has actually given us all the information. Now it depends on you whether you want to cooperate, or you still will face the music, uh, because we'll make sure that he is scot free because he actually gave all the information. We'll add him as an approver, and we'll make sure that this crime falls on you. If such false facts are given, then also it will be not be allowed because it is violative of Section 24 Indian Evidence Act. But then a person is free to make a voluntary statement out of his free will. This is, he can also make a free statement if he wants to. Now the all important provision, Section 164, it says that statement can be taken before magistrate at the request of the police. So magistrate, basically, just because the police is not trusted, now police has another course open that he will take the accused, he'll take the accused if he wants to confess, or witness if he wants to depose something, and the police thinks that probably if you wait for the trial to come, probably this witness will go away or this witness will not cooperate. So let's do one thing, let's take him to the police, to the magistrate, and the statement will be recorded before the magistrate. It will have more value because it is done before a magistrate. So we have to know that statements before a magistrate are of two kinds. One is confessional, and one other is non-confessional. Confessional statement before a magistrate can be a substantive one. So if an accused comes and says that I want to confess something, that I have committed this crime. This confession, if done before a magistrate, can be substantive. But if it is a non-confessional one, that means a witness is examined, then that is not a substantive piece of evidence, and it can be used, of course, for contradiction as well as corroboration. So the benefit of 164 from the provision of 161 is just the fact that it will be allowed for corroboration as well. Previously, only contradiction was allowed, no corroboration was allowed in 161. In 164, if it is a non-confessional one, contradiction as well as corroboration will be allowed. But if it is a confessional one, then it can be a substantive evidence. Confession is what? Confession is a statement inferring that he has committed the crime. So the animus confitendi, that is the intention to confess, that is a must. So he has to make sure he has to know that he is confessing. So magistrate has to reveal to him that this is the you. If you are confessing, then it can be used against you. It is different as to that of pleading of guilty. So the magistrate can record confession anytime during investigation, but not before not it has been made, but it is but before inquiry or trial. So it is a discretionary power of the magistrate. What are the conditions the magistrate has to ensure in order to make sure that the confession that is made is a good confession? That is, it will ensure that it is made voluntarily. It will he'll disclose his identity, that I am a magistrate and you are making this confession before me. So it will be used against you. It will be a substantive piece of evidence. On the basis of this, there can be a conviction made, and you will also say that this is the maximum punishment. So if it is a 302 and the accused seeing a movie has come and thinking that if he confesses, then his punishment will be decreased, you have to enlighten him by saying that no, this is not the case. The maximum punishment, that is death, will be prescribed to you if you confess right now. Then adequate time to think and reflect, that is a cooling off or reflection period, will be given to the person who is making such confession. If he is brought from police custody, then some time in judicial custody is to be ensured before recording confession. Then he should be ensured protection adequately. He shall be also given protection. Then he should be also asked the reason of making such confession. If all such things are satisfied, and if the accused still wants to confess, then he should be asked, and the confession should be recorded in full. Whatever he says, he shall be recorded verbatim, as far as practicable, in the language of the person making it. And then at the end, there should be a memo that it was read over and explained to the person, and he, after understanding the contents, has put his signature. That has to be there, and then sign on the same. The magistrate will sign on the same, and then take the signature of the accused or the person making the such confession, and then it will be a valid confession. But then 463 CRPC makes sure that non-compliance of any such provision laid down in 164 will not be detrimental, will not be barred, or it will be excused if it is not detrimental to the interest of the accused. But under section 91, if it is not recorded as prescribed, then no evidence can be given to show that it was duly made. So basically, if the magistrate later cannot go and say that no, he had actually he had made it voluntarily and no police was there, he cannot say that. You have to make sure that it is done in a manner that no evidence has to be given later. What is the evidentiary value of retracted confession? That you please answer. What is the retracted confession at the end of the lecture? Please answer me that if a confession is made and then retracted later, what is the evidentiary value of that? Confession versus admission. So what is the difference between confession and admission? That if on the basis of the statement alone, conviction can be warranted, then it's a confession, not a conviction. Sorry. So if a conviction can be warranted on the basis of the statement alone, then it's a confession. Otherwise, it is an admission. 164A, medical examination of rape victim. It's a new provision that within 24 hours of receiving information, rape victim has to be medically examined, and medical practitioner will will record all of these that I have mentioned and will send to the magistrate. 165 says that search by police, that police can make a search for a thing, document or material without warrant. So it says that police can make a search without warrant for a thing, document or material. So basically it's a provision which is used by police to make sure that the evidence is unearthed as quickly as possible without it being lost or misplaced. So if it is necessary for investigation, what are the requirements? That if it is necessary for the investigation, it must be relating to the offense which the police is authorized to investigate. There must be reasonable grounds existing for believing that thing required is at the place of search. Fourth requirement is that undue delay will be caused if it is to be obtained in any other way. And grounds of search also has to be recorded beforehand. And also this search has to be within the local jurisdiction. Then in such case, a police officer can make a search of a thing, document or material without warrant. Also, we have to ensure that general search cannot be permitted. So basically, this particular piece of paper, document or thing I am requiring, I know that this is with you. That's the reason police will go and search that thing. It will not say what is there with in your bag, I want to check. No, it cannot do that. General search is not permitted. Purpose is valuable evidence can be unearthed with time. Rule of ad alteram patem has no applicability in certain scenarios like this. In my Menka Gandhi case, where it was alleged that because you are not giving an opportunity to the accused and you are simply coming and searching. So in this case, Supreme Court held that if rule of ad alteram patem that the person has to be informed first. If it is to be allowed in all cases, then valuable evidences will be lost. The accused will hide it somewhere. So that's the reason it is like this provision. Irregularity in complying provision cannot amount to trespass. So it is saying that if there is an irregularity in complying the provision of 165, it will not amount to trespass, and such search still will be valid. Illegal search will not affect the validity of the seizure. So in US, what is the position is that you have to inform the source of your information. If you have to, if it is not in a proper channel, if you did not obtain it in a proper channel, then such validity of the seizure or the document is invalid in US, but not in India. In India, state of Maharashtra versus Natwarlal, the position is made clear that even if it is a illegal search, because the seizure has already been done, doesn't matter whether it's a illegal search, it will still be, the seizure will still be valid. 166 says that search within limits of another station to be made through OIC of that station. So if the police wants to search a place in another jurisdiction, then he will make it through OIC of that station. 166A, investigation outside India. 166B, testimony of witness residing in foreign territories. They can be recorded by such foreign courts and it will be sent to the court in India. 167 says that procedure where investigation cannot be completed in 24 hours. So when within 24 hours the investigation cannot be completed, then the accused cannot be detained by the police for more than 24 hours. So he has to be forwarded to the magistrate for a remand. And beyond 24 hours, a special order of the magistrate is required, and the police will transmit a copy of case diary. Then the magistrate can authorize a further custody of 15 days, which will be an interchangeable custody. It will be between police custody and judicial custody. It can alternate. And if the nearest judicial magistrate does not have jurisdiction, then accused shall further be forwarded to the magistrate having jurisdiction. In this case, transit remand can also be issued. During 15 days, which starts after the production, interchangeable custody can be awarded. 1672, that is default waiver of statutory bail. We have already discussed this at length during our previous session of bail, so we'll not discuss this. This is, you please go through that. Basically, the provision says that if the maximum period of detention of the accused is 90 days or 120 days in Odisha for offences punishable with death, life for 10 years, and 60 days for any other offence. And on the expiry of said period, then he shall be released on bail. All of the case laws are important. Please go through it. We have already discussed them at length in our discussion of bail. Now coming to other provisions of 167, which says that physical presence before the accused is necessary. Ramesh Kumar versus State of Bihar. But then here the question arises that whether now during the pandemic, what is being happen is that many things are being done in virtual mode. So please answer me: can remand at first instance be done through virtual mode? And if not, then why? Why cannot it be done? Please tell me. Magistrate can remand the accused to Army, Navy, or Air Force if the accused is subject to one of such laws. 167.5 says that for investigation there has to be a time frame, and in someone's case, if not completed within 6 months, the investigation can be stopped as well unless for special reason. So, and also says that sessions judge can vacate an order of stoppage of investigation which is passed by the magistrate. Now 168 says that procedure to be followed on completion of investigation. So 168 says that OIC has to take up the responsibility, because even if anyone subordinate to him actually conducted the investigation, being the IO, the OIC, because it has been prescribed that the OIC will conduct the investigation, so OIC has to assume the responsibility. Now, once the investigation is complete, now comes the charge sheet or the final report or the final form, as the case may be. So 169 says that if the evidence is deficit, that means the evidence is not enough, then the police can release the accused on bond to appear before the magistrate if required. But here, if he is released, the magistrate can also direct for further investigation. So magistrate will actually have the power of directing for further investigation at all stages. As I discussed, before the cognizance is taken, magistrate can direct for further investigation in all stages. Cases to be sent to magistrate when evidence is sufficient. If 170 says that if there are reasonable grounds and sufficient evidence, then he will send the same to the magistrate. 171 says that witness, if is detained against his will, that will be illegal, and evidence obtained by restraining the witness will not be valid. 172 is an important provision which says that diary of the proceedings in investigation. Basically, the case diary is to be maintained by the IO along with the station diary. Station diary to be maintained, but here it is talking about mostly case diary. Case diary is to be maintained by the IO, and the purpose of maintaining such case diary is to enable the magistrate of the day-to-day procedure and the information received during such days. As I already discussed, as I have already told time and again, police is doing what? Police is doing the job of the magistrate at the field. Because the magistrate, so it's like God could not be everywhere, so he created men. They say that. So that is the reason. If the judicial authority cannot be everywhere, so the police was also given the power that they will in turn make sure that the investigation is done and then give it to the magistrate so that he can take it from there. So here the purpose is to enable the magistrate of the day-to-day procedure and information received. We have to know here that oral evidence cannot be recorded in case diary. Basically, if there is an oral evidence, then it cannot be recorded in case diary. And the case diary cannot be used as evidence as well. This is a very important provision, that in case diary, if I've seen that many police actually what do they do is that they actually narrate the fact of the witness narrating the story. So they write it there, but you can't. A case diary will only reflect the following things. I'm telling you what will it reflect. Case diary will reflect that at such time I left the police station. The police will write this. Then I went to the house of the witness. Then I examined him. Then I seized this thing from such and such person in presence of such and such person. And then I came back to the police station. So whatever he does through the day for that investigation, he has to mention in the case diary. But he will not mention the evidence. And also case diary will not be treated as an evidence. A.K. Rai versus State of West Bengal, it says that if under 173 offense is not being made out, then on the basis of case diary alone, cognizance cannot be taken. So 172 case diary alone cannot warrant a cognizance. For that, 173 is a must. Between the police and the magistrate, We have to know that case diary is between the police and the magistrate. It is a confidential information between the police and the magistrate to let the magistrate know that these are the day-to-day proceedings that have carried out. So here, defense is not entitled to see. Defense cannot see this. The all important provision 173 now comes, that the report of police on completion of investigation. Now, probably 5-10 minutes more. I know it has been a long lecture, probably 1 hour and 10 minutes. I hope all of you are not bored. 173. The report of police on completion of the investigation. It says that the reports are to be sent without delay in prescribed form. Which reports are to be sent? That first is 157. Under 157, the preliminary report, including the FIR, is to be sent. Under 168, if a report from subordinate officer is obtained from to the superior officer, then that is to be sent. And under third thing which will be sent is final form of police after completion of investigation. Now, please know that though the section says final report, I will tend to say final form. Final form. The actual word will be final form. If it is a positive one, it can be called a charge sheet. If it is a negative one, it will be called a final report. Okay, what's a positive one? What is a negative one? If it is saying that there is a commission of a crime, then there is prime case being made out against this and this accused, then that's a positive final form, and such final form can be called charge sheet. But if it is a negative final form, that means it says that we investigated, but we could not find who has committed the offense, or we could not find out that whether this offense was committed or not, then it will be a final report. Or if it is a positive report, that means if it is a charge sheet, then the magistrate can accept it and take cognizance of it under section 1. But if it is a negative one, that means if it is saying that there is no commission of a cognizable offense, or the police, though found a cognizable offense, could not trace the accused, then the magistrate can accept the same and drop the case. But before dropping the same and accepting the same, he has to issue a notice to the informant to make sure that he will come and give a protest petition if he desires to. This is a mandatory provision, because the informant has to be known. He has to know that yes, this case was investigated, but then there was no. Basically, in many, I have seen many in 379 cases, mostly where a bike and everything is stolen. Generally, they tend to take the parts out and they sell it in Chor Bazaar. So you cannot trace the bike as well. In such case, if the police report gives the final report saying that no, there was no trace of the bike also, in such case, the magistrate will simply call the informant and say that what do you have to say, because the police could not even trace the bike even after he tried. Then the informant, if he wants to protest, he says that no, I still want to go ahead with the case, then the magistrate can go ahead and ask the police to investigate again, or also can take cognizance under 190 if he wants to, or not, or if he wants to drop the same, then also he can do it. But a notice to the informant is a must. In Bhagwant Singh versus Commissioner of Police, it was held that this concept of protest petition actually came up in this particular case that I said right now. Bhagwant Singh versus Commissioner of Police, 1985. If partly positive and partly negative, what does it mean? That if it is saying, if the final form says that it reveals that some of the people alleged, some of the accused alleged have committed the crime, but some are innocent. So charge sheet against some and final report against some. Still, then a notice has to be given to the informant and a protest petition has to be sought from the informant. After this, the charge sheet is accepted, then the cognizance will be taken and the trial will begin. What all are to be sent in the report? We'll discuss them once. That name of the parties, nature of the information, witnesses' names, prima facie case against whom made out, whether accused is arrested, whether he is released on bond, whether he is forwarded to custody, all documents and relevant extracts under 173(5). Such documents are to be also sent along with the report. Case diary, as mentioned in section 172, that has to be sent. The FIR has to be sent. 161 statements, under 173.5, that has to be sent. Reports of post-mortem, chemical examination, handwriting, expert opinion, etc., they are to be sent as well. But we have to know that whatever will be sent with the report, the copies of such documents shall also be given to the accused. If it is not given, then it will be battled to the trial. Purushottam Jethanan versus State of Kutch, 1954, it was held that whatever is given with the report, police report, those are to be given to the accused as well, except the case diary. Because I mentioned in 172 that case diary is between the police and the magistrate. So accused has no right or defense has no right. 173.2 says that all the steps taken has to be informed to the informant as well. So the police will inform that yes, this is the case. I have submitted the final form or I have submitted the final report or the charge sheet as the case. Purpose is that he can object or protest if it is a final report. 173.3 says that if there is a superior officer appointed, then a report is to be submitted through him only, and he can supervise or direct further investigation till order of the magistrate. 173.4 says that the magistrate can discharge the bond if he desires. Charge sheet without material papers is incomplete. You have to know that charge sheet, if not accompanied with the material papers, like I said, all documents and relevant extracts, case diary, 161 statements, all of these, if they are available and not sent, then it is not a complete charge sheet, and this will be beneficial for the person under section 167 here, 167.2, for a default bail. If it is not submitted along with the charge sheet, then it will be beneficial because it will not be a complete charge sheet. 173.6 says that police can indicate and request not to grant a copy of any such statement referred in 173.5 to the accused in the interest of justice or otherwise. So the police can actually say that yes, I'm giving all the documents, but please do not give this because this is a secret information, which if it is leaked, then it will actually hamper the trial, or it will cause undue delay, or there will be interest of justice affected. In such case, he can indicate the same, and the such information shall not be given to the accused. And 173 says that 7 says that police can himself furnish the copies if required. 173.8 says further investigation can be ordered on the basis of 173.2, and further report is to be submitted by the police. So here the police officer is empowered to keep the investigation open, and he can also do a further investigation. Also, magistrate can also direct for a further investigation under this section. So power to direct for further investigation under section 156.3 or 173.8 is very wide and can be made even after submission of charge sheet or final report. But we have to remember that once cognizance is taken, then trial begins. After that, there is no power to direct for further investigation. So power to direct for further investigation, as I already said, that it is very wide and it can be exercised at any stage. Randhi Singh Rana versus State, 1997, this was stated. Investigation can be kept open under section 173.8 to entitle the police to file additional evidence in the interest of justice. What is the provision of 173.8? To make sure that if there comes additional evidence after filing of charge sheet, but before taking of cognizance and beginning of trial, then in such case, it can be done. Can in such further investigation, accused be again remanded? So if there is a further investigation, the accused can it be again remanded? It was made clear in State versus Dawood Ibrahim, 1997, that yes, if there is a further investigation, the accused can again be remanded. Issuance of notice by a magistrate to the informant at the time of final report is a sine qua non. So notice has to be given to the informant at the time of final report before dropping the case. If protest petition, on the basis of that, action can be initiated and further investigation can also be ordered. As I said, if person will come and say that no, I want to protest, then further investigation can also be ordered by the magistrate. 174, 5 and 6, though are mentioned in this chapter, these are basically kind of inquiry, but as the police is doing so, it is included under investigation. 174 says that police to inquire and report on suicide. Basically, to ascertain the cause of death, the police can inquire or cause an inquest report to be made on the report of suicide. But he does not have to necessarily go to the details of who caused it. Like in Sushant Singh Rajput's case, it should have been done, but nevertheless, it was stretched beyond imagination. Dowry death is in the dowry death case, post-mortem report is a must, except where cause is very clear. Cause of death is very clear. 175 says that power to summon persons. So, to testify the injuries on the such body of a person who has died unnaturally, he can be called. But it is not a substantive evidence, so it can be only used for corroboration. So we should also know that if there is a witness who is called, so at some point, if you are called as a witness because you know a fact and you do not if you refuse to answer that question, then you can be punished under section 179 IPC. And if you give a false answer knowing the truth, then you can be punished under 193 IPC. 176 is a inquiry by magistrate into cause of death, basically in custodial death or custodial rapes or custodial disappearances. Additional inquest can be done by a magistrate. It's a judicial proceeding, so oath can be administered. So this somehow ends our discussion, and I hope that this is clear to you all. This is the procedure starting from FIR till investigation. I'm glad that 49 people throughout the extensive discussion of 90 minutes around stuck with me. I hope I was able to do justice to your time. I do not want to just take a class where you'll feel that I'm just going through it for the sake of it. I do not want you to feel like that. I hope it was beneficial for you all. If there are any doubts, please feel free to ask me. If I can clarify, I'll clarify. Otherwise, anyway, I'll get to learn something new, which will be equally beneficial for me as well. Please go ahead. Anyone has any question? Please feel free to ask. I'm sure Asif has a question. Asif always has a question.
No, sir, that's sir. Good evening, sir.
Good evening.
Sir, one thing I would like to ask that though, as you said, for further investigation, then a person can be remanded again. So that remand can be more than 15 days as recognized by section 167.
No. In no case it cannot exceed the prescribed period of the 167 to. It has to be within that period, because if you cross that, then the statute will be violated. Of course, if he has been released before that, before 90 days, 120 days has been given, he has been released 70 days. Another 50 days we have, so we can again take him to custody for those 50 days. But in no case it will exceed the entire period of that has been prescribed. Okay.
Okay, sir. Thank you.
Thank you. Anyone else has any question?
Good evening, sir.
Yes, good evening.
Hello.
Who is it? Yes, Durga.
Sir, I'm Durga. Yes. Sir, you asked a question that whether statement made other than in the course of investigation will be hit by a provision of section 160 CRPC. Is that the question, sir?
What did I ask?
Whether a statement made other than in the course of investigation will be hit by a provision of section 160 CRPC.
Yes, I asked this.
Sir, I will answer that question.
Answer.
Sir, it was held in the case of Chandra Babu versus SIO police.
Okay.
That though ordinarily investigation is undertaken on registration of FIR, the registration of FIR is not a condition precedent for investigation.
Right.
The police officer in charge of a police station is empowered to investigate any information received whether that information was reduced to writing or not.
Yes, actually
So
the position is actually now
at that
changed.
stage,
Yes,
the
absolutely.
statements can be hit by 162 CRPC.
Absolutely. It is true that if uh, if if it is done before a police, and when it was not uh, uh, investigation was not going on, and still one um, person actually came and deposed something before the police, and it was not an investigation. As I said, I asked a question also, that whether during uh, a conversation between two persons, the police records it through a voice recorder, and it was not done before a police, nor was it done during the course of investigation. In that case, whether such voice recording will be held to be valid. It was held that yes, it will be valid. It will be valid because it was the accused did not know the presence of the police. So the question of he being prejudicially biased, or he being affected, or uh, he succumbing to the fear of the police is taken out of the equation. So such revealing of the truth without the police's hard-handedness should be taken into consideration, because it will be beneficial for the justice implementation system. Our goal is to reach to the justice as soon as possible. Does not matter how it is brought, but yes, of course, making sure that the accused is not prejudicially affected will do it. So in that way, so as I narrated all the deciding factors, please note down such deciding factors: how, when, at what stage 162 will come into picture, and how it will be hit under 162. So you have to remember those. Okay.
Thank you, sir. Thank you.
Anyone else has any question?
So your question is your second FIR on the same set of fact allowed? No, sir. One can file a second FIR on the same fact or the same offense.
Yes, for the same offense, absolutely right. For the same offense, for the same set of facts, no second FIR can be made, except when it is revealing another offense altogether. Another offense altogether. Suppose, for example, I'll give an example to make it clear, that I am going by train. I'm going by train from Rourkela to Cuttack. During that passage, one person has committed theft from me. Some other person, 3/4 theft he has committed in the train. So there are, though it says same occurrence, but still it is revealing different offenses. Or for example, to be more precise, he just committed theft from me, but he committed robbery from another person. He just stole a gold chain from one person. So there are different offenses being made out here. So I gave an FIR 1379. Done. Later he comes and says that no, during this period he also robbed this gold chain from me. So it is revealing another offense altogether. In such case also, though it is uh, uh, being on the same set of facts, or same journey, or same date, still then it will be a different offense altogether. Still, that's why second FIR will be allowed. Aditya. Okay, thank you. Aditya will ask the question.
When remand can be refused?
When?
So when remand can be refused?
When remand can be refused? If the magistrate is of the opinion that this is not the person who has committed the offense, then he can refuse the remand. He can refuse the remand, saying that, I don't want to remand the accused because I don't think this is the person. The accused comes and says that this is my ID. He shows the ID and he says that his name is Vikram, where they want to actually arrest one Vikrant, and by mistake they have arrested this Vikram. Then in that case, the remand prayer, what has been made, can be rejected at the instance. Or you are saying that if you want to send him to a custody, send him to police, I mean, he's in judicial custody and the police wants to take him into police custody, only on the basis of how it will help the investigation, in such circumstances, then only such remand to the police custody will be allowed. Otherwise, such remand will be refused. So it depends. It depends on case to case when and how the remand will be accepted or refused. Okay.
Sir, I have a question. Good evening, sir.
Please ask. Good evening.
Sir, I have seen in during my internship that an investigating officer usually is being the informant, carry out the investigation and all. So whether when investigating officer becomes the informant, whether that would not vitiate the trial, because when an investigating officer will be asked to investigate the offense, it will always be, means the bias and the conflict of interest never be ruled out, or cannot be ruled out. So isn't those if investigating officer is the informant, whether it will not vitiate the trial?
Absolutely, absolutely a gem of a question. I tell you that yes, it is indeed a sad state of affairs that many times we see, especially in excise cases, as you pointed out, that the informant is actually the IO in the case. So basically, he will say that while I was going to proceeding to Saraswatiya Chhaka, I saw the accused moving in a suspicious manner, holding a wild jerry bag in his hand, and then then I stopped him and I detained him and I searched him and I found 25 liters of Moa liquor, and then I forwarded. Then because there was a prime facie case, I forwarded him to the court. Now he will also investigate in that case. In excise cases, because probably lack of staff, I do not know what do they do, but they always tend to do this. So the provision, the position of the Indian legal system was previously that it was held in a case. I'm forgetting the name of the case. I'll supply it to you. It was held that yes, in 2018 case, probably 2018 case, it has been on 2018 case, it has been held that such case where IO and informant are same. I had noted it down somewhere. Wait a second. Yes. I think it's a 2018 case. I'm not remembering the case. I'll just supply it to you later. In that case, it was held that yes, it will be vitiating the trial, and that's the reason IO and informant cannot be one and same. But then it was made clear that this case has prospective application. So anything that has been done previous to that case coming to equation, those will not be hit, and hence only the cases which will come later, they will be taken into the manifold of this law, and hence and now the current position, as you said, it is clear that IO and informant cannot be the same. As the purpose also you said that it will always be in the interest of justice that IO and informant are different, because the informant will always want to end his case into a conviction and never a acquittal. So he will do every possible thing to make sure that it will be a conviction. For example, if there is a murder happened in my family and I am the informant, I'll always want that this person who has committed murder to my family member, he should be punished. So I'll do everything to punish him. So what will be the status it will not be a fair trial, whatever, howsoever, it cannot be a fair trial given to the accused. So that's the reason it will always be welcome if IO and informant are different.
Thank you, sir. Thank you, sir.
There is a question in the chat. Yes, whether FIR can be registered on the basis of a telephonic conversation. This is the question asked by Aditya, who asked that whether FIR can be registered on the basis of a telephonic conversation. I actually said that. I discussed that in the class, so not in detail though. Yes, on the basis of a telephonic conversation or a telephonic information, an FIR can be lodged. But then such information has to be cogent, clear, and it cannot be cryptic, and it has to reveal full information or complete information about the offense. And it will reveal the victim's details, it will reveal the place of commission of the crime, it will reveal how the offense was committed. If it reveals all of those, then a telephonic message can be treated as FIR. But if it is not so, if it is not clear and not cogent, then it cannot be treated as an FIR. There is a case, I'll supply it to you. I have written it there. I'll supply it to you again.
Sir, whether that informant should tell his name on such telephonic message, whether he's bound or not.
Absolutely, absolutely. Victims' details are to be given, because the purpose is, if you do not know the name of the victim, it can be very vague. You later on you cannot track the victim who is actually the informant, who is actually the most important witness of your case. So what will be the purpose if he does not reveal the name of the victim? So the name of the informant and the victim is a sine qua non, in fact. Name of the victim, for sure. If the victim is the informant, victim has to reveal, for that matter.
But in case of public crime, just witness who is a bystander to call the police.
Still, then it will be if he does not will, if he is not willing to reveal his name, then also it shouldn't be entertained, because it will be considered cryptic, because it is not clear. Cryptic as in hello police, there is a bomb here. No, you can't say that. You'll say that I am this. I at this place I saw that there is a bomb being planted by these people. Will you please come and see that? That information will be held to be a first information report. If it is not done so, it can be anything. It can be an information, but it will not be on the basis of it. A formal FIR can never be registered. And moreover, I'll tell you the practice is what the practice is in Odisha. Especially, I know the practice in Odisha. On the basis of a telephonic information, they do not register an FIR. You try to tomorrow, or if one offense occurs to you, or happens with you or anyone of your family, if you try to call them and say that please register this FIR, they will not register the FIR. The Odisha Police Manual has a complete guideline prescribed for them. The practice here is that if you phone them and you tell them that this is the offense that has happened, they will simply register a station diary and then ask you to come to that police station at the time of your convenience, and then proceed with the formal FIR. The reason is simple. The reason is they want to know, they want to make sure that the informant, the victim, all the necessary details of the formal FIR that are done. But of course, for the purpose of counting the limitation, for the purpose of counting the for the purpose of condoning the delay, that station diary will be enough to condone all the delay that has happened between the registration of the formal FIR and the date of the occurrence of the offense. Okay. Anyone else has any doubt?
I got a doubt.
Mm-hmm.
So when a private person can bound to assist in magistrate or police officer,
Private person?
arrest a person.
I couldn't hear you. Please tell me again.
So when a private person can bound to assist a magistrate or a police officer, he can arrest a person.
I still couldn't hear you. The voice is breaking for some reason.
कि प्राइवेट पर्सन गोटे कौन माने असिस्ट करि पारे मैजिस्ट्रेट पुलिस ऑफिसर को माने कोन बाउंड कि करिया पे अरेस्ट माने अरेस्ट करिया पे मैजिस्ट्रेट जो पावर दिखते ने कि होची माने प्राइवेट पर्सन भी अरेस्ट करि परिबे जन को तो सेटा कोन बाउंड छन कि
Bound की
जा
और पूछते you are asking whether he is bound to arrest.
No, sir. Sir, my question is, when is a private person bound to assist a magistrate or police officer, he can arrest a person.
Actually, ma'am, your voice is breaking. Please post it in the chat. so that I can know. I cannot hear you. I'm so sorry. Please post it in the chat box. I'll answer it. Okay. Anyone else? She'll post it in the chat box. Anyone else if they want to? Yes, she has written it perhaps. Oh, someone else is asking, sir, what is the remedy available to victim? So what is the remedy available to victim or any other person on behalf of the victim if the magistrate does not receive the complaint after the registration of FIR is refused? If the magistrate, if he does not receive the complaint, I don't think any magistrate will refuse your complaint. I don't think they will. Yes, of course, they can refuse to take cognizance or refuse to direct. They will receive your complaint for sure. Unlike police, it will never happen that a magistrate will refuse your complaint. Whatever, however silly might be the situation, he'll always come and he will. If you go to the magistrate, he will receive your complaint. But yes, that question probably you won't mean to say that if he does not register direct for a registration of FIR, or if he does not direct for a further investigation, or if he directs that if he does not take cognizance, in such case you can challenge the same through a criminal revision before a competent authority. Now comes whether a private person is bound to assist police or magistrate, whether a private person is bound to assist a magistrate or police officer when he can arrest a person. When can he arrest a person? Yes, as it has been made clear, section 37 and section 43, it is absolutely making clear that yes, in what cases private person is bound to assist a magistrate or a police officer, and when can he arrest a person is clear. So those sections are self-explanatory. I do not think I'll dwell into that. If there are any other questions, please tell me. Please ask.
Sir, you ask another question. There is about production at fast business.
Yes.
Hello.
Yes, production at first instance, whether it can be done
Sir,
through
yes,
virtual
sir.
mode. I asked.
Sir, is there to prevent use of physical force by police for third degrees to?
Absolutely, 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 absolutely. Recently, Supreme Court
Extra
actually issued
concession.
guide.
Is there
Yes,
to
yes, yes,
prevent that?
yes, yes, absolutely. To make sure, because you must remember there was a case, perhaps in Andhra Pradesh, during this lockdown, where it, we practically see magistrate cannot see the accused, what is happening with the accused physically, or if they have tortured at places where it is not visible, at invisible parts of the body, private parts of the accused. And then in such cases, it is practically impossible for the magistrate to actually ensure that whether he has been tortured physically. So in that case, if you allow remand through virtual mode, it will be catastrophic, as it has been during one of the cases where the father and son during the lockdown, where they were taken up, they were bitten back in blue, and probably their private parts were injured, and the magistrate could not see, and because it was done in a virtual mode. And after that, Honorable Supreme Court issued guideline making sure that whatever can be done through virtual mode, but the first instance remand, that has to be done physical mode, even if it exposes the risk to the concerned magistrate, because many a times we see that all the accused who are COVID positive are brought before the magistrates, and yes, they still have to at least inspect, not if very closely, at least see that whether he is fit and fine, whether he is there is no coercion or force applied to. That is the purpose. Okay.
Thank you.
I asked many other questions also. Why is anyone not answering all the questions, or it has been too long a lecture?
Sir, pranam.
Here all.
Sir.
Yes,
Hello.
Pranam ma'am. Pranam ma'am. Tell me, Shravani ma'am. Tell me.
Sir, I have a question.
Yes.
Can a private person instruct a pleader to prosecute an accused in a court against whom a police report under section 173 of CRPC has been filed.
Can it please repeat it? It's a long question. I forgot again. Please repeat.
Yes, sir. Can a private person instruct a pleader to prosecute an accused in a court against whom a police report under section 173 of CRPC has been filed?
Well, that means you're saying that whether a private person can appoint can appoint his personal advocate, right? Do you mean to say that?
Yes. Can he
Because the state,
instruct a pleader? Yes.
yes, because the state has actually appointed prosecutors, public prosecutors, or APPs who actually take over the case. So you want to say that whether private persons actually can engage their advocate of choice because probably they are not happy with the proceeding that is being conducted by the PP. The
Yes, sir.
question here has been made clear in CRPC itself around 302 or 1, I forget, uh, uh, that he can assist the PP. He can at best assist the PP, and whatever he can appoint with the permission of the court, he can appoint, and that person, that private advocate, will assist the PP, or he cannot directly move before the court though. Whatever he has to say, he will say to the PP, and the PP will in turn present it to the court. So he can very well assist the PP. You can appoint.
Thank you, sir.
Sir?
Yes? Sivashish?
So you have asked a question that evidentiary value of retracted confession.
Yes. Please tell me, what is the evidentiary value of retracted confession?
So, conviction can be made on retracted confession if it is made voluntary, if court presumes that it was made voluntarily. But
I'm saying that once a confession is made, and later he is saying that no, I did not make a confession. When did I make a confession? He is saying this right now. So what will be the evidentiary value of the confession that he made earlier?
So then, in my point of view, if retracted conviction, when retracted confession is the basis of conviction, then court have to accept that. Hello.
Yes, if the retracted conviction, if there is a retracted confession, then what has to be done?
Hello. Sir, can you hear me, sir?
Yes, I can hear you. I can hear you, Sivashish. Yes, I can hear you, Sivashish.
So, if retracted confession, when retracted confession is the basis of conviction, then if he retracted that I have not done any offense, then I think court has to accept it.
Accept what? That he will accept that he has not done any offense, right? That's what you are saying.
No, but means
the prior confession will be accepted. You please answer in one word, whether the prior one will be accepted or the later one.
So the latter one.
Yes. The position here is that if there is a retracted confession, then you have to make sure that there is further corroboration from any of the evidence. Without further corroboration, you can't straightforward go and use it as a substantive evidence, because I said that a confession made before a magistrate can be used as a substantive piece of evidence. On the basis of it, a conviction can be made. So if that is the case, but if it is retracting later, then that has to be corroborated in material particulars by any other evidence. There can be any circumstantial evidence, there can be other evidence which will corroborate the same. Then only a retracted confession can be used. Yes. So Swetangi Das has actually answered this question correctly. Yes, it is not a substantive piece of evidence. It needs corroboration. Nirlipta Dhal writes, 2-person go to PS. Which one will be FIR? You please answer, ma'am. You cannot write my question and get away with it. You please answer. You try to answer. As you wrote the question, you have to answer it so that it will be interactive. Nirlipta ma'am, if you can hear me, please answer the question.
Good evening, sir. A person who has signed over the FIR informant. I think so. I'm not sure about it. That's why I asked it.
True. But my question was if both of them go to the place together, and because one of the state is to be registered first, because the uh, provision says that only the OIC is empowered to take an FIR, I mean register an FIR. So the OIC will be one person. He'll register one FIR at once and then endorse it, and then go ahead to register the second set of information that is being brought. So the information that is reduced first in point of time, first
Sir,
it is indeed by IIT. That
excuse me,
will
sir.
be the
I think the person who reads first, the person who informs first, that will be the FIR. I think so. I'm not sure about it.
Absolutely. Who informs first, but I am saying if there are two persons who want to say that this is the offense and they reach the police station at the same time, in that case, the position of law is that the Supreme Court has made it clear that the police using their skill or their intelligence will have to make sure that this is the person that I want to register as an informant, and he will register his information first, and the other piece of information that has been brought, that will be clubbed or that will be added as a 161.
By summing up all these things, whether I can say that the person who is willing to file the FIR at first instance, two person may intended to file FIR. The person who first willing to file FIR, that will be FIR.
Absolutely, he should be willing, but then another party should be willing to register it as well. Lopamudra ma'am, please can you just turn off your mic because it is disturbing. Turn off the mic. Lopamudra ma'am. Yes. Anyone? So now the position is that if there is also a person willing to register the case, but the OIC has to register it first. OIC has to make sure that yes, I am the I have to register it. So there must be a person willing. If that is registered, forget about everything. You just remember this: the first in point of time, whatever information has been recorded by the OIC. By any person who has come before him, that will be treated as first information report, and other information that will be brought later, those will be tagged maybe with FIR, clubbed with FIR, or they can be later used as 161 evidences as well. Okay. Another 3-4 charts are there. Can a criminal court an accused to admit and deny documents even when the accused prefers to maintain silence and states compel? Can a criminal court compel an accused to admit and deny documents? Admit and deny documents even when the accused prefers to maintain silence and states that he would neither admit nor deny the document. Absolutely, he cannot be admit and deny. I couldn't get it. That yeah, admit or deny. You mean to say that admit or deny a document? Admit or deny, perhaps. Yeah. In that case, he either admit or deny a document. When the accused prefers to maintain silence and states that he would neither admit nor deny, the accused can never be used. I mean, anything cannot be used against the accused without his will. So if he does not prefer to say it, then probably it can be used. It can be used against him because it is his conduct of choosing to be silent when he is being asked by the court regarding the admissibility or deniability of a document. But he can never be pressurized or he can never be forced to make an opinion or make a statement during that regard. As Durga is actually clear that yes, it is a very good session, and probably we need another session involving question answers. A lot of questions are coming. I'm glad that people, all of you have such questions, and probably it only means that you probably understood the chapter well, because if you did not, then there would not have been so many questions. I'm glad that this worked out. Anyone else has any doubt? Right. If there are any other doubts, please post them in the group. We can take them. I'll try to answer them in the group itself, or probably at the end of the next class, which will be probably a short class than this, we'll take up all the questions. Okay. This should complete our discussion. 2 hours long session. Thank you for bearing, and thank you for listening to me patiently. Have a great evening.
Sir, I have a question.
Yes, please. What's the question?
Sir, if the OIC refused to lodge a FIR, then what remedy should be taken?
Ma'am, did you not join the class earlier? Because I specifically told the remedies, but then again, for your information, I'll tell you the remedies. The remedies available if the OIC does not register the FIR is that the SP can be approached. There is also a way to approach the High Court under Section 482. You can also approach the magistrate to directing the police to investigate or register a FIR under Section 156(3). There are 3 courts available to you, and the magistrate also, if he fails you, or if he does not direct the investigation, or he directs the police to register the FIR, in that case, the course open to you will be a criminal revision, as we discussed. So these are the remedies available to a person.
Thank you, sir.
Okay. Thank you, everyone. Anyone has any question, we post them on the group, because it's 7 o'clock already, and I'm sure it's very late. So we'll conclude the session here. Again, one question came, and my habit is I can't just let it go like that. Shravani asked that an informer, while furnishing false information to the police, defamed another person. False information to the police, defamed another person. Then what will be his liability? There will be 2 liabilities. He'll be charged under 193 of IPC for falsifying an information. Then again, he'll be liable for defamation as well. So there will be 2 liabilities occurring to him. And again, as we discussed in the tort class, if anyone was there, for a defamation, there can be 2 course of mechanism. One can be a tort, which will be a civil wrong, and then you can also approach the criminal court under IPC. So it can be a lot of money being spent later if the informer will actually defame another person while furnishing all information. Okay. I'll not take any other questions. It's already late. It's 7. Great night to you all, guys. Bye bye. I hope it was a good session for you. Thank you. Bye.